So in the case of Flavornet, as we mentioned, the client had 12 years of successful claims and wanted to develop a product that allowed them to increase the solubility of plant sterols in a suspension. It had issues on shelf life, pricing, suspension fallout, and various other ideas. Basically what happened is that the client looked at different articles, they looked at different patents. They didn't bring them all to court, but they did a lot of this from memory. And really when I went through this and the client illustrated how much they had done, I was pretty happy that the client was going to win. However, within the case, the judge basically said that they were not sold by my client's testimony, and they were in fact more convinced by the CRA's testimony. And what bothered me about that was that my client had actually gone through a patent, talked about why I hadn't applied, provided evidence of correspondence with other scientists and suppliers, and evidence of the experimentation itself at the sites of commercial suppliers providing input. And all of this was discredited in view of the CRA scientist view, which is fine, except for the fact that the CRA scientists never provided any evidence. They didn't provide any patents. They didn't provide any articles. They didn't provide a single piece of evidence that could be used, in my view, as a valid rebuttal to say that something was state-of-the-art. I think this is particularly troublesome because the legislation for SR&ED is not a Canadian definition. It's actually an OECD definition. That if we look at the definition for R&D tax credits in Section 43 of the IRS Code or inland revenue in the UK, we all use verbatim the same definition in our acts or code. And therefore, since it's the same wording, we would assume the law should be relatively similar. To put this in perspective, if this case happened in the United States, the client clearly would have won because the IRS auditors or reviewers are subject to something called a rebuttal presumption. And what that means is if the IRS reviewer, unlike the CRA Research and Technology Advisor, wants to express a negative opinion, they as a scientist are required to provide evidence of where a similar development might have occurred. And that would be scientist versus scientist. That's exactly the way I assumed it would work here, that one scientist provides evidence to support their opinion, another scientist provides evidence to support their opinion, and the judge would compare the two opinions. The courts have actually used an explanation or comment that they talked about the role repeatedly of the expert witness towards the judge or the courts is to be, the expert witness is to play the role of a set of prescription glasses through which the judge can analyze the results and make an informed decision. What I've always assumed that would mean was that the judge would ask one scientist for support for his or her opinion and the other scientist for support for his or her opinion. But that would be based on evidence as well as merely the credentials that they have from an academic standpoint. In this case, I was comfortable that my client had 3 pieces of evidence, which was infinitely more than was supplied by the CRA, so we had this in the proverbial bag. Yet, despite that fact, at the end of the day, the fact that the CRA reviewer, Dr. Hassanen, had a PhD and had professed that there probably was routine methods, although she did not supply any of them, was seen by the judges as a valid position, and that the client therefore did not meet the criteria. I could go on and talk about some of the specifics of how the judge actually went through the 5 criteria of Judge Bowman to the point of saying that there was no hypothesis of the client's within the client's project. And I kind of find that comment offensive, to say that there was no hypothesis. The definition of hypothesis is basically an assumption based on existing knowledge through which further development can be made. And it was clear to me that the client had provided numerous hypotheses in the description itself, both on emulsifier ingredients, shearing methods, different temperature techniques, that those were previously outlined in the patented technology itself and exemplified in the work, and that the client did experiment with various alternatives and come up with the conclusions. So again, at the end of the day, I felt the client really didn't get the fair shake at the end of the day, and maybe it was as much not due to the science as much as our understanding or misunderstandings of the tax court process. In particular, things that are submitted online when you file the tax court appeal aren't necessarily reviewed by the judge at all. In fact, you have to submit them again when you get to court, and you have to submit them in paper copy in order for them to be considered. So we may have had some relevant information that was submitted but not considered by the judge at all. Again, this is a lack of familiarity with the tax court processes as much as a lack of scientific knowledge. I also found, in my personal opinion, that the courts were not sensitive to the needs or time of the taxpayer. We actually spent 3 days to discuss this case, and I believe it should have easily been done in a morning. That the issues were misunderstood both by the Crown and the appellant, or the respondents, or the judge and the Crown in this case, but also that the whole scheduling process of the tax court was inefficient. You're told to arrive at 9 a.m. on a certain day, and then you actually wait the whole day. We didn't actually start our court case till 3 p.m. the same day, so we had to sit. Clients and I had to come from out of town. The Crown's counsel had to come from Halifax. The judge from Ottawa. I mean, it was a big event, and we sat there for 7 hours doing nothing. So the first day we really got very little done. The second day we again had similar problems where we couldn't get the case done because of other scheduling routines. But what was really nice, and I'll say this as a thumbs up, is that on our third hearing, we actually did it all online on the internet, and it was fantastic. It was easy to log in. It was convenient to everyone. It was respectful of everyone's time. And my one question was, why couldn't we have done the first 2 hearings like that? And it would have been a great experience. So again, in doing this, I think that the tax court, in my opinion, can provide a basis for building a very strong SR&ED process, particularly where the Canada Revenue Agency is deleting projects or deleting things that can illustrate eligibility when there's never been more of a need for it. So again, I'd like to say that ultimately, I feel, despite the results of this case, that the tax courts are an effective method for dealing with disputes. However, there's probably a lot to be learned, and if taxpayers are going to go to court, they may want to consider hiring professional legal counsel, what we call the general procedure, rather than using the informal procedures that have been used by myself and some of my colleagues to avoid the legal fees and hassles, but that also may result in not following all the legal policies correctly. At that point, I'd like to leave it open to moderator comments, and after which we'll take a short intermission from the course, and Judge Bowman and Todd Louie will come on to discuss most of what we've talked about today, but also some ideas for the court process, and in fact the object and spirit of the legislation itself, what was meant perhaps by the 5 questions, and are they being interpreted in the correct way.